Welcome to the Notes to My Legal Self, AI Insights, where law and AI collide. Get ready to level up your legal game with us. We've got career advice, cutting-edge developments, mind-blowing legal tech, and more. Know someone making waves in the legal AI world? Nominate them, or even nominate yourself. We love courageous souls. And don't forget, we want to hear from you too. Ask questions, drop comments. Let's build a community of legal superheroes. But here's the deal. We're all about to have a blast. AI may be serious, but we're here to make it fun. So buckle up, get ready to power up, and let's embark on this exciting journey together. Now, let's introduce your fearless host, Olga Mack. Get ready to dive into the awesomeness of Notes to My Legal Self, AI Insights. Let's go.
Hello, everyone. Welcome to the Notes to My Legal Self, AI Insights. Today, we're going to talk about the approaches in California and Florida with respect to AI and practice of law. Exciting times. We're going to see states do something about it and speak, and then get it right and get it wrong, and maybe do it again, and maybe try to harmonize. All of this is going to be a ton of fun, and we're in the very beginning. And I am looking forward to this conversation with Kassi. Hi, Kassi. Welcome back.
Hey,
You've been a repeat guest. Please quickly reintroduce yourself.
Yes, I am an attorney who works in litigation, largely e-discovery. So that means I've been working with AI for quite a while. And I know that's the same for you too, Olga, right? You've been using AI yourself in your own
I've been using AI for a while. I've been in all kinds of disruptive technologies, including AI and ML before they were cool, including crypto and blockchain as well, and data for well over 10 years now. And I'm really excited that the rest of the world is now excited about this technology. Right. I'm excited that the world is excited. How about that?
I think that that's one great thing about being an attorney that we're starting to see more. And of course, Merriam-Webster announced this year that I think the word of the year is authentic, that sometimes as attorneys, we think that we need to be more serious and more maybe calm demeanor, but I get really excited about all this stuff. And I think it's okay to talk about these new technologies and the transformation that may come from it and be excited about it.
Yeah. So let's be excited together. How about that?
Yes.
So I'm not going to, because we talked a lot about your background and folks know a lot about me, but there may be not everything on LinkedIn or maybe things we haven't talked about. So I thought before we dive deep into Florida and California and the links to the actual words of the states are in the comments, and I'll let folks open it and read if they want to. I'll do a fire drill question, quick and easy, so that folks to get to know you a little bit better. So how about this? Trial or negotiation?
Negotiation.
Okay. Billable hour or fixed fee?
Wow. I'm going to say billable hour in case my law firm is
going to be easy.
I'll say billable hour in case my law firm's watching.
All right. Since when are you conformist?
Yeah, I know, right?
Legal pad or digital notes?
Legal pad. I love handwritten notes. These are like my to-do list. I love the process of writing it. It sticks in my brain a little bit.
All right.
How about you? What do you prefer, handwritten notes, or do you like digital more?
It's really funny. I like creating like with my hands. But then I have a compulsion to digitize it because I actually don't own a lot of paper because I don't know it feels very special and it feels like it needs to be properly stored. I don't know. So I actually end up either scanning or digitizing it one way if it is important or destroying all evidence, so to speak. So, legal thrillers or legal textbooks?
I think legal thriller. How about you?
Definitely a thriller. I just think a legal textbook is a waste of money, especially if we talk about the leather old school, where basically it's 90% publicly available cases with just an order of things. I think they add very little value. So absolutely never bought them. Don't recommend buying them. Don't even recommend buying it to my students. But I do like thrillers. And if it's a really good how-to book, then I think it would be a much, much harder conversation. All right. Paralegal or secretary?
I don't.
Sorry, I didn't say
wow. That's tough. I've had legal secretaries who saved my life, and the same for paralegals. So I I don't know if I can pick.
I think it's both for me.
Yeah, yeah.
All right. Expert witness or character witness?
I'm going to go with expert witness because I feel like that's going to be such a thing that we're going to be dealing with deep fake and synthetic data that's going to be, that's such a, and I love true crime and I love like forensic files and DNA, but now we're starting to see that for digital forensics be its own true crime resource or subject area. What about you? Are you more character witness because there's juicy
No,
stuff?
no, experts. I love experts. I have deep admiration for subject matter experts. I find it fascinating when people reach depths in their expertise. I call them subject matter charismatic, and I enjoy meeting people, whether they're on my side. I prefer them to be on my side or not.
Mm-hmm.
I really have a fascination with subject matter experts. I find that I respect people who have depths of knowledge that I cannot achieve in any reasonable time. Okay, courtroom style.
I like that maybe it's the being more from the South or from Texas, like that persuasive theatrical, maybe
The entrance.
the big entrance, or just because I think there are a lot of good attorneys who are maybe not good at presenting. They don't necessarily have a dynamic way that they present the information. They're presenting information as they should, but I think if you're really able to be like dynamic and connect with the jury, or maybe it's not a jury, the judge, I just think that makes the information resonate more. So I think having that dynamic speaking style, I think it just makes you better at relaying a message.
I'm all about vivid language and pictures, show and tell. But actually, the question I was asking was more related appearance as opposed to the speaking style.
Oh, okay. So you mean like how people should be dressing in court?
I don't know, pantsuit or skirt suit, color or black and white. I don't know.
I like wearing pantsuits just because I'm very cold natured, but I think you do have to be mindful of the court rules, but I think interjecting a little bit of color, there's nothing wrong with that. Women being able to wear maybe bright colored lipstick, I'm a big fan of that. So if that's your jam, and I know you're fond of bright colors, Olga, so I imagine you.
My style is pantsuit for the opening, skirt for the closing, and always a power jacket. And yes, depending on where I am theatrically speaking, with a color that may punctuate the conversation. Maybe not. Sometimes black and white is exactly what the doctor ordered. All right. Cross or direct?
I think cross, right?
Yeah, definitely cross. That's just much more exciting. Pro bono or billable?
I have a lot of pro bono. I love doing pro bono work. Of course, you do billable to pay the bills, but pro bono, I put in one thing I like about where I work is we do have a strong emphasis on pro bono, and I've been able to put in a lot of hours in pro bono, and I think we should all be doing that if we're able to. So I'm a big proponent of social access to social justice and things like that.
I'm with you. Last question.
All right.
Judge's chamber or courtroom? Courtroom? I think I prefer the judge. That one I thought about it. The answer is like with both, but I actually like the judge's chamber because you get like the real person on both sides, including the judge. Okay, cool. Let's talk about AI and in Florida and California. If you were to summarize what those documents say, what would be your 1-minute summary?
I would say if we use the AI ethics approaches of AI ethics is either AI for good or AI for not bad. I feel like the California has more of an AI for good vibe and Florida has an AI for not bad, whereas California is thinking about how it can be used and things like that, where Florida is being more focused on be mindful of these things, don't do these things only.
Yeah, I would say for me, maybe 2 things, maybe 3 things. Actually, the longer I talk, it's going to be 5 things, but let's stick with 3 things. One is flexibility versus sort of specificity, and they seem to be on the 2 different spectrums there. 2 is education and practical guidance, and they seem to be on the fairly different spectrums there. And then the big one is innovation versus caution. I really do think that what was driving California is more this innovation mentality. And it could be because I'm in California and I'm biased and I know the members who've written it. But it definitely strikes me with that vibe. And California, Florida is definitely seems to be, based on the document without knowing individuals, on a sort of much more conservative and cautious side.
Yeah, and I would agree with you. And the good thing about the Florida, it's an advisory opinion that's open for comment. So I think if anyone's listening and they wish maybe the Florida bar advisory opinion took it a little bit step further, there's an opportunity to have your voice heard and add your comments to that. And I completely agree with you. And I think, and maybe you can talk about this a little bit, Olga, as I understand the California bar's guidelines were maybe somewhat helped by what the law.mit.edu task force initiative kicked off.
The ASA, I think, was involved, at least in some extent. At least we've publicly shared our findings. And because we are in California, I believe we talked enough that folks either explicitly reviewed them. I don't know exactly the details, but they definitely were aware. And in law.mit conversations and findings, we amassed a set of data of conversations to attorneys, leaders in this space, in the law firm, in-house, government, academia. And we definitely came out with a sort of approach much more focused on innovation. And I do think that it had influence. I was not directly involved. I believe DASA might have. At a minimum, we, both of us, by virtue of being in California, have spoken in many forums to many peers. And yes, that might have had an influence, though I will not speak exactly what was going on in folks' mind when they were drafting it. But yes, it resonates with what we have found, for sure.
Yeah, and two things that I really like about the California guidelines is the proposal of a requirement that everyone needs to have generative AI training. I think that there's a lot of talk about it. It could be bad, it could be good, but I really wish there was more education and practical education around it, not just surface level education. Just these are the instances where it may be useful. These are the things we need to be aware of. Just all of that. And because we're still seeing, even a few weeks ago, attorneys using ChatGPT to write a brief. And I think it is just, I think, comes down to lack of education. And then the other thing, touching on education, there's an acknowledgement of what are we going to do? What should law schools be doing? And I think as we're seeing the impact of the legal profession, but we're also, I feel like the law school structure is getting further and further removed from the market demands of a new attorney, and it's going to get more difficult for young attorneys. So I think we have to be very intentional about how are we properly preparing young associates to enter the market.
Yeah, it's interesting. California is definitely emphasizing the educational part. And when you start speaking education, it's a whole gamut, right? From law school to retirement, because that's what we do. But then there is a sort of a secondary conversation, and somebody in the comments mentioned the AI officers. One of the most popular jobs that seems to be trending now, AI officers. And of course, no one has that job title as a prior job title. So by definition, everyone who's applying is underqualified, but could be relatively qualified, meaning there's nobody who's done this before. So you may as well apply with all kinds of credentials. But it is a question of education. And I believe the United States is looking for an AI officer, our beautiful country, and many folks in corporate America and governments are looking for that. And that very much reminds me, when I started practicing law, people were looking for SaaS lawyers. Remember that? SaaS lawyers? And I remember actually having interviewed people would ask me, "Are you a SaaS lawyer?" And I would say, SaaS is not a legal discipline. explaining, of course, this to a business professional was not something that was a productive use of my time or their time. But what I was saying is that, and we no longer see SaaS lawyers. We see folks who focus on commercial or product or litigation or employment or whatever. But those point in time titles do speak to education. The need to level up your education to the point that you have it in your title and you have it in your job description, that if you actually have not done it before like everybody else, you should level up your knowledge so you can have constructive conversation. That's what, to me, SaaS lawyer, AI officers, or blockchain leader, like
Right.
that, to me, when you have to frame something in technology as opposed to a discipline, to me that's a very point in time indication that knowledge is scarce and you can level up by learning.
Yeah. And by learning, it's doing, right? It's playing around with these tools. I think there are a lot of people, there are some people that are talking about AI, but have they actually gone and built their own GPT? Have they played around with figure out how to get your hands dirty? What's the muscle memory with using these tools? And that's really what people should be considering and doing if they have an interest at all in those kinds of career opportunities that are going to start to occur. And also, it just lets you have a better understanding of the technology itself if you play around with it. So I think I was listening to a LinkedIn Live yesterday with Judge Xavier Rodriguez, hosted by ASEDS, and that's something he talked about. He has published a paper through Sedona Conference about the use of generative AI in the legal profession. And he really encouraged people find a low risk situation to use GPT, maybe personally, and just play with it, engage and figure out what it's like, because it is a little bit different from the search engines that has been a resource for us. So I think it's, again, the education, the messaging, making people feel like, yes, you can use it and it's not going to make the world end if you use it in the right way.
Yeah. All right, let's go back to California and Florida. Let's talk specifically, ethical concerns, like things like biases and confidentiality. And maybe I'll frame it. For the biases part, I can say I was a little surprised that neither one of them really talked about it. With all the sort of vibes on various spectrum, there's actually, I would say little, but let's just say almost none, if not none, about biases. And I thought, you can generalize based on education or whatever that is emphasized, that would be included. But I think it's a massive thing. It's a big thing. And I wish it was explicitly addressed, because there are biases in technology and law. And when law and technology get together and produce a baby, it happens to inherit all of the challenges of the two parents. And so I think it's what's important miss for me. And that's number one. And the second thing about confidentiality, I found interesting that California was very practical about it and very trying to be helpful, whereas Florida was very much focused on protecting client confidentiality. It was much more client focused. And that was, to me, that was very interesting. So question to you, how do you feel about the bias admission? Do you think it's included? How optimistic do you feel about that? And to confidentiality, what do you think about the approaches?
My recollection reading the California, there was some language about access to justice. And to me, I've been using AI, as I mentioned before, for a while, but it's usually in the context of corporation A, corporation B, and their corporate business email. And so the issue of bias in our use of those tools, it doesn't really, it's more an issue of, is the tool adequately analyzing the data pursuant to the way we've trained it? But there have been a lot of other uses of AI in criminal law that's been gone unchecked. And I think what we're starting to see is some of the prosecution use of AI is starting to get a more scrutiny. We're seeing that from executive orders and things like that. And I think maybe highlighting a little bit more and focusing more, we're talking about human rights, we're talking about and an area of practice of law that underrepresented people often do not have as robust representation as an individual who may have more money. So I think thinking about how we tackle that is very important. So I did like that about the California guidelines where they did talk about access to justice, which is, again, very important. The confidentiality, I think that's just going to it's an important thing to talk about, but I think it's going to get more and more challenging as these tools become more and more embedded in our everyday lives. As I recall,
the reality is the confidentiality conversation we cannot avoid.
right.
It is actually in the model rules. It is in various case law. It is the bedrock of the legal practice. So I'm not surprised that it is addressed. I think this will get much deeper. It was interesting that positioning was somewhat different. One is more about the client, one about sort of practical things you can do. Both are probably important in reality because this is actually a right that a client could assert and could lead to disbarment. And I think this will be unwrapped. There's more to come, so to speak. Bias, on the other hand, is a little different, right? Bias is the sort of somewhat secondary. It's embedded to us being officers of the court and all of that. But there is not necessarily an enforceable right attached to it. And training models that require data that could be already biased and historically biased. And you're absolutely right. When we talk about people's liberties and criminal law is exactly where we do that. That becomes very interesting. But let's focus on California. I think let's talk about the virtues and vices of California. I think for me, on the virtue side, I do this emphasis on innovation. And I find that emphasis super liberating because law and the practice of law has not changed in a while. So for the California to emphasize essentially importance of innovation and effectively acknowledging that it has not been happening for a while, and we probably ought to do this, was really actually interesting approach. It's much more open-minded approach that I would expect from most bars, including a very progressive, relatively speaking, California bar. And yes, it was wrapped in the access to justice, which the cheese that makes the broccoli go more tasty. But it's much easier to talk about innovation when the access to justice is presented to you. So it is a little bit of sugarcoating, important sugarcoating, but nonetheless, the document very much talks about innovation and yes, access to justice as the important positive externality of that. And so for that reason, combined with education and flexibility, I really thought that California took an interesting approach. And I think it's a huge virtue. What do you think?
I personally really liked the California guidelines, and I think the innovation not only in how it'll run the practice, but maybe there was some acknowledgement of how you bill for it. You, of course, are not going to be billing for what you would have done if not for the technology. Do I think that means that we're going to move towards a fixed fee model? No, I don't think so. I think that there are a lot of young associates that we're getting more and more. I'm not young. So a lot of associates that are getting more and more work. And I think that there's some work that we can do, assuming that there is the proper protections in place that could make lives easier, could make the day a little bit shorter, and they can have more time with their family in the evenings. But yeah, I found like the acknowledgement, the fact that they had to say you can't bill for what you would have normally done. I thought that was that and
to me that seems unsaid because that's by definition fraud.
Yeah. I felt like,
am I exaggerating?
Yeah. And Florida additionally also talked about costs. And I think that there's that underlying the business of running a law firm. I think that some people may be concerned about. I, again, still firmly believe we have a lot of work to do, and a lot of us are doing a lot of work, working really long hours. So if we can use the technology defensively to make our lives easier, I think there are some great opportunities to explore.
Yeah, it's interesting. As much as I actually haven't decided if I like California more than Florida, because I see challenges with California as well. I think one of my big challenge is, as exciting as educating folks is, and I think very important, it is, I would be very careful to over rely on that statement. And especially when you put ownership of education and responsibility on individual lawyers. And what I mean by that is that, for example, I think it's pretty clear under the model rules and California rules, with which I'm pretty familiar, and major other rules like New York and Florida, that we have a duty to supervise AI. Just like we essentially have a duty to supervise paralegals and
Mm-hmm.
um, our secretary's assistants, and we can't choose which one
Right.
is more important, because they all are in fact important. But the challenge is there's very little guidance in model rules or in any state's equivalent on how those big principles are left to our judgment and what I call are not operationalized.
Mm-hmm.
And I am really worried when something is not operationalized, especially if it's going to be judged inside 2020, especially when you have a technology that is moving this with massive speed, especially when you prioritize innovation. I'm a technologist first, and I worry that I may get it wrong. I really do worry about that I may get it wrong. Heck, I'm not the only person who is a technologist who worries that she may get it wrong. Sam Altman went to Congress, I think, saying exactly the same thing,
Mm-hmm.
over relying on even highly educated folks like lawyers to make a right decision when they have a sort of hyper focused on the teeny tiny problem for their client, maybe massive for their client, but in the grand scheme of things, small. I think that's like asking to run before you can crawl.
Mm-hmm. Yeah, and it's interesting that you talk about making it operationalizing the use of it. And, that's where my brain just always goes there. There's an expectation that there should be SOPs in place for the use of it to outline how do you use it, how do you validate it. And a lot of that just comes from the discipline from having used it in litigation, and you have to do that. So and that's maybe a blind spot for me, that I assume everyone's going to think, if I use an AI, a generative AI tool, I'm going to build an SOP, and I'm going to indicate who can access it, and I'm going to make sure they understand the specific use cases of how they'll use it and how they'll have to validate it, because we would never use AI in litigation and be happy with the first output and not validate it. We would never do that. That's not defensible in any way. And so I think just like having, again, probably a blind spot for me, because I just assume everyone should be doing that. But I think that as we look at AI policies, we think of it as a global policy, but I really think that you merely need to think of use cases, maybe either broad categories or specific, as you're onboarding these tools, and build out those policies talking about how this is being used, how it was prepared, address the confidentiality privilege issues, who can have access to it, how you need to properly use it, and including how you validate it.
Yeah, it's the vast majority of lawyers are not practicing in big law where they have a lot of resources. I think and I'm trying to gradually maybe go to virtues of the caution. I'm actually not a very cautious person. I'm actually a risk preferring person, but I think here this technology can have impact at scale.
Mm-hmm.
And when you have something unknown with, catastrophic outcomes, that is, I don't know how likely, but even if it's small likely, you should probably proceed with caution. It reminds me when I had a driver instructor and we were driving and the sun was like bright in my eyes and I was hitting on the gas. And the poor guy had almost a coronary at the time. He said, "Oh, when you're blind, you do not put on the gas." At least when I'm in your car. To me, kind of the situation, like you do not put on the gas when you have a lot of blind spots. In the front, in the back, on the side. That's a time to proceed with caution. That's a time to slow down. When I look at Florida, that's a little bit how it feels to me. A very cautious approach, partially because there are a lot of lawyers who do not practice in big law or even big departments who have fewer resources, who may not have the time and space to develop best practices, actually probably need guidance from their state bar or even ABA for best practices, and don't really have a capacity to manage this enhanced, possibly catastrophic risk. And so the caution actually may be a virtue here. And that's what I think really is, if you look at Florida approach, it certainly will have negative impact, and we can talk about it too. But I can definitely see how you can say, hey, a lot of blind spots. Yeah, let's slow down. Makes sense. Don't be a 24-year-old Olga who just hold up her car, right? Be a somewhat more responsible adult and member of your respective bar.
Yeah, and I think that as we're comparing them, the great thing is that both states have released either advisory opinion or guidelines, and they're opening it up to public. And I think that's a great thing that we're seeing across the board. Is the Copyright Office has done this, the OMB has done this in relation to their guidelines for Biden's executive order. And we're seeing Florida, even if it's the more cautious of the two that we're talking about, it is still saying, we're publishing it. We would love your comments. Please give it to us. And I feel that that's a thing that's great and positive. And not all state bar associations have issued guidelines yet. Maybe don't even have a task force together. A lot of states have, but the fact that
I think they're all learning from each other. The reality is, this is actually, I was going to ask you, maybe put another question for both of us. They are somewhat different, but they both open comments. And I think there will be no shortage of comments on both sides. And my guess is that they may be even talking and reciprocating, because they may be doing exactly what we did with law.mit. We compiled this open source data set that we share with bars and organizations to help them get it right, not start from the ground zero. And so I guess my question is, do you think we end up with sort of a few schools of thoughts in the United States, like 2 or 3, hopefully not 50. Let's not go there. That's not usually where we end up in our regulations. We end up with sort of New York approach and California approach type of thing. Or do you think through this conversation at a state, national level, we will converge to best practices that are more or less on the same page?
My hope is that we do more or less, that there will be some alignment. And I know, of course, ABA has formed a task force, and I don't think they've issued anything yet as far as guidelines, but I think that's probably going to be seen as a great resource for individual states. We've seen that with the ABA model rules regarding competency in Comment 8, where I think 40 of the 50 states at the last time I checked have adopted, the requirement for competency regarding technology. So I think that there are probably a lot of smaller states maybe that would love to not have to recreate the wheel. Let's be honest. This is definitely a scenario of work smarter, not harder. I don't think any bar association should have to start from scratch if there's already some great resources to work from and maybe collaborate with. And the vibe I'm getting is that people want to have a safe space to talk about it because they really maybe they don't understand the technology very well, or they're afraid to put themselves out there as not knowing the answer, which is something a lot of attorneys, we don't like sometimes. And I think having like a consortium, a brain trust kind of getting together, or just being a resource, again, work smarter, not harder.
Yeah, I am certainly hoping for convergence, maybe for a couple of reasons. One is that I would like the pace of innovation to be equally distributed among states when it comes to law. Law is very important. It's has justice as an important principle to it, and you really should not justice depend on the state you're in the nation. So the pace of innovation, I think, is very important. I think things like effectively forum shopping
Mhm.
not good things. They're obviously a strategy when you are a company or an individual enforcing your rights or thinking through various protections, and there's always going to be an element of that. But again, if that goes to the heart of justice, I
Mhm.
think it may be an individually good strategy, but we're talking sort of collective optimization here. I think that's challenging. I think because, and I will list maybe item number three, which I think is a big, I have a few more, but I'll leave at that, is that access to justice is really a massive conversation when it comes to technology and law. Because today we have a small percentage of population consuming more than 80% of legal services. And I don't mean just individuals. There's a lot of small businesses that are
Mhm.
basically underinformed and underrepresented, from employment to lease negotiations to loan negotiation, like in every step of the way. And this is, we're not talking about below poverty line. We're talking about upper middle class sometimes. So we are not, as a nation, really familiar with what it means to understand and fully appreciate your legal rights. We have accepted not knowing as a default baseline, which I think technology can change by
Right.
embedding in your experiences. And so that implication of access to justice is very important, balanced with the dangers of this technology. So some sort of balancing act of that is uniform across the nation around how fast we go and to determine the direction is right, and then maybe eventually speed up, because in the end direction is always more important than speed, although speed becomes important
Mhm.
when you underserve, let's just say 80 plus percent.
I definitely agree with all of that. And I think your comment about access to justice, there are a lot of small emerging businesses that they just don't have the funds to maybe get the proper legal advice. There could be some potential great opportunities for small businesses, but to your point, we do have to still be careful because there is the potential for inaccurate results combined with automation bias combined with scalability. It can have some really impactful negative results if the tools aren't used correctly. That's, I would agree with that. And actually, whenever I was at the NIST workshop and they were getting feedback from people about the workshops that were initially selected to kick off, someone said, well, we should really be adding access to justice to that because we need to be mindful. We do think that these technologies are going to be so transformative. We really have to be thinking of underrepresented groups and making sure they don't get left behind. And we didn't really see these conversations before whenever the internet came up and came live. I do think that there are a lot of people out there are a lot of voices saying we need to make sure underrepresented voices, underrepresented people who have historically been biased against are protected. So hopefully that will help move the dial so those protections are accounted for and put in place.
We're coming to the end. I do want to talk about a few things. Maybe you can start this one. Somewhat unusual conversation, but I think it's definitely important, even though law is a very jurisdictional adventure within the borders of the state by definition, because that's what laws cover, whether it's state or United States. I'm talking about the country level now. How we as a country, as collective, handle it also affects increasingly global world. It's not unusual for companies to shop for incorporation forums, for litigation forums, And that usually is structured by default laws and approaches that jurisdictions take. So I wonder if you have any thoughts about competitive stand of United States industry, services industry, which is a significant part of our GDP, and the importance of getting it right, getting this speed versus direction balance, both at a sort of state levels and national level.
I think that's an interesting discussion point. I think for emerging technology as a whole, we're seeing, just going back to even just blockchain and how that's being regulated and addressed and how that might impact innovation, the how copyrights are being treated or protected. I think those are all things that are very important right now, because there are a lot of, it can impact innovation. Let's just be completely honest. So I think striking that balance between concern and making sure there's some caution and guardrails put in place, but also not stifling the innovation, because it's easy, as you said, to forum shop for people. There could be brain drain, right? There could be people that would start a business in the US and they see the regulatory landscape is not very amenable to this business that I want to start up, whatever emerging tech it is.
Or the market is not innovative, still prefers to bill for things that could be done in seconds.
And so they
before they even care about outcomes, they're gonna fill in their invoice.
Yeah, exactly. So it's just very easy now for people to spin up a company internationally. So I think that's an important thing to be mindful of. And as you said, we've historically been very innovative in a lot of ways. And that is something that the broader, of course, President Biden executive order is addressing, is what's the impact of people and jobs and what can we do to minimize that impact. It would be very unfortunate for us to be slow at innovation and yet jobs are still impacted. It's like a double whammy that would
services is a big export for the United States. Legal services specifically are a big export for the United States, precisely because it has historically been, if you want to be very objectifying, a high-end consultancy that has been justified through the powers of monopoly and expertise, sure, but mostly monopoly. So because that's what a monopoly does. So the impact on services as a component of our GDP is actually very important. And I think getting it right, I think, is no pressure, but a big deal. So very important, I think, to think through the future of law and impact on the economy. I think we're coming to the end. Maybe we can end with the question, or more of a sort of thoughts about, you're an individual lawyer and you can pick your favorite place, whether it's a solo practitioner, a big law lawyer, mid-sized firm, in-house, government, whatever. You can pick your favorite place or not. What is one or two things that you think you should do, given that active conversations happening at the bar level, but you still have clients who, either decreasing your budget or questioning costs or challenging invoices? You have a lot of unease about this technology that feels possibly overhyped, though it does do some magic when you do ChatGPT. What is one or two things that you would recommend to a normal practitioner who may not be a technology lawyer to do today so that they can thrive tomorrow?
I think assess what they do in their practice that is maybe an operational thing that is not directly something that they would bill the client, but needs to be done and maybe takes up their time or time of another resource. And if they can find a way to maybe use generative AI to streamline that process and make it more effective, for someone who is a billable person or someone who works in-house and any hour over 40 is free, being able to streamline that process, maybe it's business development or maybe it's an operational thing. And let's be honest, legal departments have operational data that they have to manage. Just anything like that, I think test it out and see and get that win and see how you can implement it in a safe and effective way, and share those results with your colleagues and maybe decision makers and stakeholders, and then build out a plan of how you may implement this, more broadly. I think it's a potential great opportunity for small and mid-sized firms because they often maybe don't have the resources available. In-house departments as well, a lot of times they don't have a lot of resources. So I think anyway, it can maybe give time back to attorneys. I think it's in a defensible way. I think it can be a wonderful resource for them.
Yeah, I think I'm with you on all of the points. I would say maybe three things for me. One is that you actually mentioned there's a lot of smart people grappling with this question. And this has been going on now for a while, from what at MIT to California to Florida to the ABA. You do not have to start from the beginning. You definitely can learn, especially if you engage in what I call active learning. You read the comments, you read the drafts, even outside of your jurisdiction, you contribute. The act of responding requires you to level up just by definition, because most lawyers would not just want to share their knee-jerk reaction or their emotional reaction. They would actually want to educate themselves. And the process of responding helps you get there. I think number two would be some sort of active education. There is increasingly a lot of free and paid services that help you learn all kinds of things. And I think there will really, a little bit of education actually goes a long way, and you can decide how much more of it that you need. And I do think that sort of practical playing with a tool, what I call skin in the game, is very important. If you still haven't opened ChatGPT, do that. And if you still haven't built something really silly or not so silly, useful with AI agents in ChatGPT or some other service, do that. It's actually fun and empowering, and in my case, somewhat addictive. So absolutely do that. Those are probably the top two things that I would recommend. Is that you really need to get into the pool and start swimming. And I guess number three is that what you mentioned, I've been now advocating for a while. Not everything is high stakes and risky. A lot of legal practice is actually non-confidential, non-risky. No, I do not mean legal advice. I do not mean filings. Those are absolutely. But then when you run a business of law, there's a lot of stuff like marketing that is public, that you share public by definition. There's a lot of routine tasks. And you can definitely find those low cost, low risk experiments, whether they're for your personal life or your practice, and just get your wheels rolling about how much different your practice can be. And I think those are the three things that I would recommend. Our time came to the end, Kassi. 53 minutes later, and we could go on for a long time, but we will not put any more burden on our audience. We will call it a day, and this will be the end, or until next time, because I think
until next time.
Yeah, next time. More to come next time. Thank you so much for joining. I always enjoy our conversation.
I always enjoy coming on, so I appreciate the invite as always.
Oh, amazing. Let's do this again. I think we're doing it again next week, talking about FTC. So thank you so much, everyone, for joining. And I hope this was useful. And I love all the conversations that were going on in the chat. Hopefully we addressed all questions. Thank you so much. And have a good day. Bye, everyone.
And that brings us to the end of another thrilling episode on the Notes to My Legal Self AI Insights. We had a fantastic time exploring the fascinating intersection of law and AI with you. But hold on tight, because the adventure doesn't stop here. Stay connected with us on social media to continue the conversation, share your thoughts, and be part of our incredible community of legal enthusiasts. Together, we can inspire, learn, and make a real impact on the world of law and AI. If you enjoyed today's episode, we encourage you to share it with your friends, colleagues, and anyone else who could benefit from the exciting insights we discussed. Let's spread the knowledge and enthusiasm far and wide.